So this is the next important segment in our ongoing, closely watched masterpiece theater, tips and strategies for the successful closing. We've talked about cash to close, so important and yet frequently misunderstood. We've also talked about closing remotely, like from a foreign country or a different part of the United States. Not as easy as it looks, doable, but not effortless. Now let's move on to trusts. We see this all the time. So people will go to an attorney and they'll get a trust. Great idea. Then they'll transfer the property into a trust. You have to do it. I mean, why do the trust if you're not going to put the real estate in the trust? And then it basically is forgotten until you sell the property, and then it sort of comes back onto your display. Couple of things, in no particular order of importance. When you establish that trust, make sure that you have a copy of it, because when you go to sell the real estate, you're probably going to have to give a copy of that trust to the buyer's title company. They need to be sure that the person holding themselves out as the trustee of the trust is in fact the trustee pursuant to the terms of the trust. Now, I have to say, of all the things we run into, I don't frequently run into people not having a copy of their trust. Thankfully, either they kept a copy or the attorney that prepared it kept a copy. People were not really creating trusts back in the 1970s and early 1980s. I mean, wealthy individuals, high net worth individuals were, but most of us were not. So most trusts have been created in the last 10, 15, 20 years, so they're available. But have a copy of the trust ready to give to the title company so that they can be sure that, in fact, the people who are holding themselves out as trustees of the trust are, in fact, trustees of the trust. Now, let's talk about this. Have you set up a bank account in the name of your trust? Now, as a practical matter, a lot of people have, and that impresses me. So there are a lot of people, when they get that sort of pep talk or they get that speech from their trust attorney, now you have to get a taxpayer ID number, we'll get to that, and you have to set up a bank account, and you need to really observe trust formalities. It's not just this sort of paper creation, like we're creating a trust and we're putting the property into the trust, but otherwise it's as though we own the property and there is no trust. A good trust attorney will really alert and educate their clients. Really treat this property as though it's not your property. It belongs to the trust, and you're the trustee of the trust. But that's what's really happening here. So you would ordinarily open up a bank account in the name of the trust. And you might go so far, and I would recommend it, by the way, getting a taxpayer ID number, also called an employer identification number, for that trust. And you can do that. You can apply online with the Internal Revenue Service, and typically, barring any complications, you could be issued that taxpayer ID number then and there. Now, question, must I have a separate taxpayer identification number for my trust to sell real estate owned by my trust? Answer, no. So that is not required legally, but I recommend it certainly. And the reason why I would recommend it is because, and again, all of these videos are just based upon different snippets and anecdotes and incidents that I've seen that have impacted a closing negatively. I've made a mental note of it, and I thought at my very first opportunity, I'm going to pass this along. So I saw a real estate transaction where I represented the seller, where the selling trust, did not have a separate taxpayer ID number. And the decision was made somewhat on the fly, again, after the purchase and sales agreement was signed, but before the closing, that the seller wanted to get a separate taxpayer identification number for this trust because of the fact that some prior trustees had passed. And it seemed like maybe the taxpayer ID number that we were working with at that time belonged to a deceased party, which obviously can create complications. This is a trust that had been in existence for some time. So we applied, as we normally would, to get that taxpayer ID number online, informed by the Internal Revenue Service that we couldn't get it online, that we had to apply for it in writing. There was a fax process for that, and we did that. But the process, beginning to end, took about 3 to 4 weeks for that taxpayer ID number to be issued. Thankfully, we didn't have buyers that were moving in. Thankfully, we had a patient and understanding closing attorney, so people didn't freak out or lose their minds. But yes, that delayed the closing because that decision was made on the fly and not really properly researched or considered at the outset of the transaction. So something to consider. Now, if this trust is in your social and you're good with that and you don't plan on changing that, that's fine. But if your plan is to get a taxpayer ID number for this trust, do so before the closing or begin that process before the closing so that the closing is not delayed. Now, what happens if you don't have a bank account set up in the name of the trust? Is the closing attorney or title company going to write the check to you personally? In other words, I am John Q. Public, trustee of the John Q. Public Revocable Trust of 2025. And I walk in on the day of closing and I say to the people at the title company, although this typically would come out before the closing date, I never set up an account actually for this trust. I just want you to make the check payable to me directly. Now, there are some people out there that cut corners, and they will do that out of expediency or to avoid drama, but technically it's not correct. The proceeds should be made payable to the owner of record and the seller. And if the owner of record and seller is a trust, then the proceeds should be made payable to a trust. Now, if you're in the title business or you're a real estate attorney and you're watching this video and you say to yourself, well, geez, what's the harm? I mean, are we elevating sort of form over substance, or is this sort of an obsessiveness with protocol? Is there really a downside or a risk here? Well, I mean, one risk seems to me would be that you decide to cut that corner and make the check payable to the person and not the trust. And then the following Monday, somebody walks through the front door of your office and says, yeah, I'm one of the beneficiaries of that trust. And I'm just wondering, when are you guys going to close? Because I haven't seen any money yet. By the way, we only see it all the time, where trustees are selling real estate, not just for the benefit of the trustees, but also for beneficiaries who are actually expecting to receive proceeds upon the completion of that sale. So for you to make that check payable to the trustee individually is a real risk, and it's a violation of protocol, and it could expose the title company or real estate attorney to litigation in a very foreseeable way. So, but will that seller push back? Always. And we see that all the time. Oh, this is crazy. I shouldn't have to do that. I should be able to get the check made payable to me personally. I've seen people open up bank accounts on the fly. Okay, fine, I'll open up a bank account. They open up a bank account on the day before the closing. And we talk to people about this too. Don't overlook the fact that that bank is probably going to put a hold on anybody's check going into a newly opened account. So it's all about having information. I think the common denominator in closings going awry is when people don't go into the closing process with an adequate level of knowledge and information and expectations. And expectations are so important in this business. I was told many years ago that you get out of life what you expect. If you expect a lot from life, you're going to get a lot. If you don't expect very much, you're not going to get very much. I don't know that that's true in real estate. I think in real estate, people's expectations are not organic. I think they are the product of what people tell them to expect, what their realtor tells them to expect, what their lawyer tells them to expect. And a person that goes into a real estate transaction with a trust, but no bank account, or a trust, but they don't have a copy of it, or a trust, but it's in somebody else's social security number, and that should be good enough until they find out it isn't. These are the people that wind up complaining and frustrated and pointing fingers. And usually it's just because they weren't prepared for the real estate transaction itself. So hopefully this video aids in that preparation. If you are selling property in a trust, those are some of the things that you really need to pay attention to.